Right, everyone. It is 6:05, so we begin. Good evening, everyone present here. I am pleased to welcome you on behalf of Center for Corporate Law and NLUO Orissa today. I am Shivani. I will be the moderator of the session. Sir, the center is truly privileged to start this year off hosting a virtual session with a stalwart of a corporate industry, Mr. Vinod Kothari. He is a seasoned professional in the field with an extensive background as an author, trainer, consultant, chartered accountant, company secretary. The list just goes on. And through his firm, Vinod Kothari and Company, he has been engaged in the practice of corporate law for over 30 years. As you all know, the Center for Corporate Law has always strived to foster an interest in the intersection of business and law at a student level. So, therefore, sir, I'm pleased to share with you that the session has been highly requested. We received over registrations from over 15 law colleges, and once we opened for registration, we've been flooded ever since. And as students, we rely on your articles, your webinars, and today we not only have the pleasure of learning more about the contemporary issues in the insolvency and bankruptcy regime, but we also gain to learn from your experience and insight on the same. So, due to the limited time, we have structured the session in a Q&A format, which was collected from the audience beforehand and hand-selected to present before you. Moreover, if time permits, Sir has graciously agreed to take up a few questions in the end. So I request everyone to type in their questions only in the chat box. We may not be able to take all of them, but we will certainly try to accommodate your questions. So, with your permission, sir, Shachi will take the session forward and we can begin. In the meanwhile, if I can be of any assistance, please do let me know.
Sure. Shivani, thanks a lot.
Thank you, sir. Over to
Thank
Shachi.
thank you so much, Shivani. So, firstly, I'd like to, extend my humble regards on behalf of the entire Center for Corporate Law. We consider ourselves extremely lucky and immensely grateful, interacting with a seasoned professional such as you. So, we're all gathered
Uh,
here with, yes, sir, please, I'm
mhm.
so sorry.
And Shachi and Shivani and others, it's indeed my privilege as well because the teacher in me always loves to interact with students, and it's a great pleasure that I'm interacting with students from several law colleges, as you mentioned. I've also been seeing on social media the extensive interest that this
Yeah,
particular event has gathered. So I'm extremely happy to see you all join today, and would be certainly anxiously looking forward to interacting with you all. While time is definitely a limitation, but we'll love to hear from all of you to the extent possible. Shachi, kindly go ahead.
Thank you very much. So that's so very gracious of you. Thank you so much. Before we begin, I'd like to request everyone to kindly mute yourselves so that we do not cause any disturbance. So we have gathered here with immense curiosity to hear from you. And with your kind permission, may I kindly proceed with the questions, please?
Yes, please go ahead.
Okay, so the first question we'd like to pick your brain on is that the Insolvency and Bankruptcy Code was enacted with the twinfold objective to one, meet the time-bound insolvency resolution, and two, to ensure value maximization for distressed assets. So this revolutionary piece of legislature has completed 6 years in existence. In this regard, we pose a two-pronged question to you. One, how far has its objectives been met as per you? And two, what could be the future course of action as per you to further the objectives of this legislature? Over to you, sir. Thank you.
Shachi, that's a very interesting question, and I think to begin with, this question is most expected because, as Shachi mentioned, I think that's the expectation that everyone had from this law. Insolvency law in no part of the world is new. Insolvency laws have existed for hundreds of years, roughly 400 years old. Insolvency laws go when it comes to UK personal insolvency regime of 1600 something. It's been there for hundreds of years, I would say. In India as well, insolvency laws, the so-called provincial and presidency towns insolvency laws were drafted over 100 years back, and they've been there ever since. When it came to companies, companies did not have a separate insolvency regime. Companies winding up was always captured by the basic provisions of Companies Act. However, still subjected to insolvency principles developed in course of personal insolvency. So insolvency laws were there all the time. Now, as in India, so also in a lot of other countries in the world, the essential objective of any insolvency resolution process is time. When it came to time, the erstwhile winding up regime suffered from tremendous delays. Delays were essentially because of the judicial processes involved, the involvement of the official liquidator. Several years back, there was a committee called IRADI Committee. I'm not sure if some of you would have heard about this name, IRADI, ERADI, IRADI Committee. And the IRADI Committee published a report on the performance of winding up in different parts of the country. It published data about 4 different regions. And it came to the conclusion that over an average, roughly about 11 years was the time taken in conclusion of insolvency in different courts in the country. But then it gave regional data. And the interesting piece of information is that the eastern region, as I'm sure and all of you would expect, took the first place when it came to number of years. And the average time taken in eastern region was 25 years. 25 years is the working life of a man. So 25 years, and that too on an average. When we last examined, there was a case of some Imperial Royal Bank of China, which was pending in the court since 1945. And some official liquidators confess that the number of sheets on which handover of charge happens, one OL goes and second OL comes, there were some 8 sheets of paper filled up with signatures of handing over charge as well. Now, few days back, I'm sure you would have read in the national press that the Calcutta High Court now concluded the oldest insolvency matter in the country, which was initiated in 1952. So that's the state of the time taken when it came to insolvency. There was nothing wrong in insolvency principles. We had principles even then. We have principles now. The principles have changed a bit, but principles always existed. Insolvency principle has existed in every part of the world, and by and large, globally, the principles are similar. Barring local differences, the principles are by and large similar. So the reason why we needed a consolidated insolvency law was because we're fed up with the days of the DRTs, we're fed up with the SICA, we're fed up with the delays in courts on the winding up matters, and therefore needed a fast process where value could be maximized without losing time. Now, 6 years on after the promulgation, effective implementation happened in December 2016, so just crossed 6 years. And what does the data reveal? The data shows that of the pending insolvency matters, corporate insolvency resolution, nearly 64% of all admitted applications have taken more than 270 days. If 270 days is the time, celebrated time within which we expected to complete insolvency, 64% cases have taken more than 270 days. When it came to liquidation, the timeline is 1 or 2 years, as depending on when the liquidation commenced. And it says more than 50% of liquidations are outstanding for more than 2 years. Even something called voluntary liquidation, where the role of courts is actually minimal. And there's absolutely no reason for a court to be concerned, because that's not a case of insolvency. It's a voluntary winding up. There again, 36% of matters are outstanding for more than 2 years. So the timelines that we currently, the performance cannot be said to be satisfactory at all when it comes to timelines. Every time there is an IBBI amendment of the regulations here and there, trying to squeeze some time here, some time limit of 30 days is reduced to 21 days, 21 days reduced to 18 days. So we try shrinking some days here or some days there. Unfortunately, the biggest loss of time is happening in the courtrooms. That's where timelines are just not seen. The problem may be largely infrastructural, given the fact that lots of benches still don't have full-time members. For a long time, NCLT did not have a full-time president. NCLAT had a lot of vacancies for quite some time. So those are infrastructural issues. But I'm still saying, even if the benches are working to full capacity, the issue essentially is that benches are clogged with tangential applications. Any major insolvency, there are some 20 what do you call IAs, and there are so many IAs and so many irrelevant applications to be settled. So a whole lot of time of NCLTs goes in handling tangent applications which do not touch on the core substance of insolvency. And therefore, when it comes to time, I actually cannot say that the code has been a great success. But in a certain other respect, the code has been a great success. And that's very important to understand. So I'm not therefore giving no marks at all to the code. The code has done a great impact on what you call the default culture. Now, that's something which is very important to understand, because prior to the promulgation of the code, for anyone who borrows from bankers, the money borrowed once is almost like dahez mein aaya hua saman. You don't need to give it back, because the procedures were never strong enough to take meaningful recovery action. SARFAESI Act did have some impact though, because SARFAESI Act, of course, had limited applicability. SARFAESI, while technically can be extended to any asset, but practically SARFAESI is mostly relevant for something like, what do you call, peripheral assets, something like land, buildings, immovable property, peripheral, non-core assets. Let's say a guarantor's house given as a collateral, one can use SARFAESI for that. So SARFAESI was still usually being deployed. But when it came to um, enforcing contractual commitments, there was no strong deterrent against a defaulter. IBC made a tremendous difference, particularly Section 29A. And the huge impact that Section 29A has on a defaulter is that once you lost the trust of your creditors, once you defaulted and therefore lost the trust of your creditors have taken you into insolvency, you have lost your right to be in business forever. You can never gain back in no way, whether by way of CIRP or by way of purchase during liquidation or by way of purchase as a going concern sale or even by way of a sale under SARFAESI Act. Once insolvency has been initiated, no manner of grabbing back the assets of the defaulted entity exists for a defaulter. So that's a huge cultural shock to the business fraternity of this country, which over decades of default dragged into the CRPs and the DRTs and the Sikh industrial forums. They've been used to enjoying bankers' money with impunity. So there, IBC gave a strong message that those days are over. Now, if you've defaulted and lost the trust of your creditors, you lost your right to be in business seat forever. So that's the big impact that IBC has made. Timeline is something which is still, I would say, work in progress. I think reducing timeline for the insolvency practitioners by few days would not make a major difference. Major difference can be made only by examining the biggest bottleneck in the process, which is the adjudication process. Declogging the NCLTs, removing the clog, making sure, and I think when I read the list of questions, there was a very interesting question, and I'm sure Shachi is going to ask me that question. So sooner she does, I'll be anxiously waiting to answer that question, which is on use of artificial intelligence. Can we do something whereby the time taken by benches can be reduced, at least on matters which do not require application of mind? Technically, application of mind is required in every single case, but there are a lot of cases which are purely factual, circumstantial. So those matters, can we not assign it to an artificial intelligence of sorts and let a machine answer the question instead of the judges of the NCLT? So, Shachi, that's a long answer to the first question, but feel free to go ahead.
So thank you so much. You carved out such a beautiful answer, especially backing it with data and giving us an insight into the default culture. So the next question I'd like to pose to you would you like to take the AI related question right after this? I mean, if that
Yes, I think that does make sense. We can let's talk about the question. And Shachi has not even read the question. Shachi, would you like to read the question?
certainly, yes, sir, certainly. So the question goes as such: can artificial intelligence and machine learning help in reducing the number of frivolous applications filed before the adjudicating authority and improve the system to reach the goal of resolution in a time bound manner? What are some career opportunities? I'm so sorry, sir. Yes.
That's the career opportunity is
Sorry.
the next question. Let's talk about, I would love to call it frivolous application. for any applicant, his application is never frivolous. I mean, I might see it's a frivolous application, but that's my view. But for the person who filed the application, that's the most important, piece he could. I mean, that's his most important contribution to the law of insolvency. So, frivolous application is a qualitative expression, but let's talk about application now. Use of artificial intelligence. While one would love to say that justice is essentially requiring application of mind, and judicial application of mind, that's the specialty of mankind. The rendering of justice is not something that we can leave to a machine. The day machines start rendering justice, will probably become slaves of machines, and that I think would be unfortunate for humanity in general. But in a lot of manners, a lot of respects, after all, every application of mind requires some basic work. There's some basic research, there's some basic gathering of data, there's some basic correlation of data to make it coherent for the judge to ultimately come to the final concluding line, the so-called judgment. And that's where artificial intelligence can do a lot. If chatbots today can answer questions, I mean, they'll find some kind of KR, some kind of share, somebody answering a question. You know for sure that what is the one who's answering is not a KR share. The one who's answering is actually a machine. So if a chatbot can answer your questions, if artificial intelligence can help you in various other medical prescriptions can be done by machines, for example. Now, something as sensitive as medical prescriptions, that they can be done by machines, we find no reason why at least a large part of the framework or background work for judiciary also cannot be done by machines. To this end, UNESCO has done a substantial work in terms of trying to see the relevance of artificial intelligence and machine learning in judiciary. Even our own Supreme Court has initiated, there's probably an artificial intelligence committee formed by Supreme Court. And in addition, there is probably an initiative called SUVAS, whatever that stands for, SUVAS, where the Supreme Court has started using an app which would assist judges in translation of documents into regional languages. I think that would probably also help judges to translate evidences into English language if at all the judge wants to read it in English. But in addition, a lot of work, for example, background research, gathering data, gathering evidence. So the so-called frivolous application that Shachi was talking about, and I think what she might probably mean is incidental application, miscellaneous and incidental application. For example, when it comes to IBC, a whole lot of applications pertain to somebody seeking extension of time. Somebody was supposed to do something in time. Let's say a claim was to be filed within 30 days of commencement of liquidation. The claim was not filed in time. I'm coming now for extension of time. So if something like extension of time or extension of time for liquidation or extension of time for doing something, now what is in it that cannot be done by machine? After all, if there have been 5,000-6,000 applications in the past where extension of time might either have been given or might have been denied, that could form the background for a machine. A machine can learn from those 5,000 to 6,000 cases in the past and then assist the judge that this answer is either quite likely to be no or quite likely to be yes. The NCLT judge may still apply his mind. Nothing stops him from applying mind. But as the judge gets more confidence that the machine's verdict is his verdict as well, he can have increasing confidence in the abilities of the machine. So we are the ones who need to be sort of confiding in the ability of machines, but machine learning, artificial intelligence, to my mind, can reduce the work of NCLTs to quite a lot of extent. And believe me, unlike civil cases where cases could still be relying more on evaluation of evidences, in NCLTs, barring those substantive matters where rights or property rights of people are involved, in whole lot of matters, the matters are purely incidental. They don't require so much of adjudication. So those matters can definitely be tried by artificial intelligence. So I think there is a lot of help in terms of reducing delays, reducing timelines, particularly for rendering research for the NCLT members. If you meet NCLT members, most of them would be cribbing about they not having enough of research assistant. They probably say, I don't have a research assistants. There's no one to assist me with case law. There is no one to assist me with writing of rulings. Writing of judgments take a long time. Sometimes you find there are 50, 60 page worth of verdicts. So that tremendous amount of writing, that's something which can be largely taken by machines, and that would reduce the drudgery of the work that NCLTs currently do. That would therefore reduce delays and enable the members of NCLTs to spend more time on qualitative work than on pure text writing. So it does help a lot. Shachi.
So thank you so much for tracing through the viability of AI and how it can be introduced in the incidental applications to eliminate frivolous applications. Thank you very much, sir, for enlightening about us about the same. So my next question to you, if I may kindly have your permission to proceed to the next question, sir. So, my next question to you is regarding the recent farrago about withdrawal of resolution plans. So, many a times we have seen in the recent past that several committee of creditors wish to withdraw resolution plans post the assent by the adjudicating authority. While the jurisprudence tilts against such practice, we would really like to understand your views about the same, sir. Over to you, sir.
So technically, once a resolution plan is admitted, it becomes an order of the court, and therefore it becomes binding on all the concerned. So the decision of the committee of creditors, where courts have time and again gone to say that the commercial wisdom of the COC is supreme, and therefore the commercial wisdom should be allowed its free play. That commercial wisdom translates into a ruling of the court, and therefore it now merges and becomes an order of the court. And therefore the only way to thereafter go for anything which amounts to interfering in the decision of the court would be a sort of review or amendment. Now, normally the view that we have all been having is that review is something which cannot be done by NCLTs. NCLTs can review their rulings only on factual errors. The review therefore has to go at the next level, which is the NCLAT. So in my perception, once a resolution plan has been approved by committee of creditors and once it goes to NCLT, once NCLT has passed orders, then it becomes definitive. It then partakes the character of a verdict of a court, and therefore the question of withdrawing that does not arise. However, Section 12A, of course, provides one gateway that the creditors may decide to actually, withdraw an application. That's before its admission. And in addition to, if at all the creditors, for example, let's say the applicant, after making an application, the applicant comes to the court and says that my application was filed under some mistake of law, and therefore I want to withdraw. So there might be circumstances where the courts may use, their jurisdiction to permit withdrawal of a case on factual grounds, which may be so very case specific. In general, I would say generally stating the law, if let's say I'm a creditor and I filed an insolvency application, now it's not my application anymore, because the moment I filed insolvency application, the application becomes a collective pursuit of all the creditors. As law students, you must all understand, recovery of money is a personal remedy. A creditor is trying to recover his money. The moment I move to an insolvency process, it's no more recovery of my money. It now becomes a collective proceeding. It becomes a case of resolution of insolvency so that dues of all the creditors need to be paid. There's no question of one single creditor going and saying my case has been settled, I have been paid, and therefore I would like to withdraw the application. But that would be completely defeating the whole collective process. So as students, you must all remember that enforcement of security interest is a personal right. Recovery of money, surface action, for example, is personal right. Recovery of money is personal right. Insolvency is not recovery of money. Insolvency is a resolution process where we take a collective effort. It works collectively to the benefit of all the creditors, all the so-called claimants, and therefore the question, even the original applicant cannot come and say that I have been paid and therefore I would like to withdraw. But that would be misuse of the insolvency process, actually. Shachi.
So, thank you so much for demystifying this thought provoking proposition on the withdrawal of resolution plans. So, if I may have your kind assent, could I kindly proceed to the next question? Thank you very much, sir. So now I would like to present you a question on the recent issue pertaining to Jet Airways. Sir, in this matter, the NCLAT basically has ordered the airline to clear employees' duty, the provident and gratuity in full. Sir, however, such payment obligations fall beyond the scope of the waterfall mechanism. So, what are your views on the same, sir?
So first of all, I have to say that with great humility, we're talking about a ruling of an NCLAT, and therefore, in great humility, with the absolute, this is an academic discussion, and therefore we're doing it academically. None of us are familiar with the facts of the case are apparent in the ruling only, but we are not concerned with any particular fact here. So as by an academic discussion, now this NCLAT ruling in the case of Jet Airways draws upon earlier rulings of several NCLAT benches in several matters. To start with Mojer Bayer, there was the case called Sergeant Godiawala, there was a ruling called Rainbow Papers. And then in the case of Jet Airways, the court, the bench of the NCLAT, drew lessons from each of the former rulings of NCLAT to come to a conclusion that social security benefits, for example, PF dues, for example, gratuity fund contributions, these are sort of beyond the liquidation estate. And they were drawing from Section 36, etc. But in my very humble view, the Mojer Bay ruling is pending an appeal for Supreme Court. Rainbow Papers, I'm not sure, but I think there is another ruling also, which is starting Sergeant Godiawala is also pending in Supreme Court. And the Supreme Court therefore may or may not agree with the ruling of NCLAT. My sense is that the Supreme Court will not agree with the ruling of NCLAT. Because to say that PF dues or gratuity dues fall beyond Section 53 will be to disrupt the very basis of Section 53. Section 53 is the soul of insolvency law. If I were to say what is one section that sums up the essence of insolvency law, and once again, I'm aware that I'm addressing students and practitioners or would-be practitioners perhaps. So I must say the quintessence of insolvency. Insolvency is all about a shortfall. Insolvency means what? Shortfall. Assume that you invited 20 people for dinner and 40 people turn up. You had prepared food for 20. You now got 40, a crowd for 40. So how do you make sure that people eat? I mean, in what order of priorities do people eat if the food on table is sufficient for all? In other words, we have a situation of sufficiency. Then the priority order doesn't matter at all, because everyone, no matter in what priority you come, you'll still get belly full. But if the number of guests is much more than the food on the table, then the question of priorities, because whoever comes, if I go first, I'll probably eat plate full. So the question is, what is the priority order? And therefore, the priority order becomes the very essence of insolvency. And therefore, Section 53, which lays down the waterfall, is the soul of insolvency. And Section 53 anyway starts with what you call a non-obstante clause. The whole IBC that we had non-obstante, but all the more Section 53, because it overrides contracts, it overrides statutes. For example, tax payable to a government is a contractual obligation, no doubt on that. The wages payable to employees is a contractual obligation. The wages payable to an employee, salaries payable to an employee, even let's say the managing director's salary, contractually the company is bound to pay. But the question is, when we talk about a situation of shortfall, who is to be paid first? That's where the waterfall order comes. So the waterfall, which is the order of priorities, that is the essence of insolvency law. And none of the benches should try to make indents into Section 53. In the past, the unfortunate thing with Section 529 and 529A of Companies Act 1956 was that several court rulings made dents into Section 529A also laid priority order. 529, 529A and 530 of 56 Act also laid the priority order. The priority order, of course, was different because we reordered priorities when we wrote the IBC with due discussions by the BLRC. The priority order was highly rewritten. A lot of rewriting was done, but that was done with a conscious thinking. But irrespective, courts should not try to make dents and should not try to, drill holes into the scheme of the waterfall, because the water has to fall in that priority order. If it drill a hole into it, so that water starts getting into a separate gateway that would breach the very essence of the very balance of Section 53. So the ruling of Jetaways is inspired by early rulings in Mojaber, etc., which are anyway before the Supreme Court. Now, what I would say is as follows. To the extent there are employees' PF contributions which have been deducted by the company and not paid to the PF authority, that's something the company is simply a fiduciary. It's not my money. The money was deducted from the respective employees. I'm simply a conduit. I'm simply a pass-through. That money, therefore, has to go irrespective of that. That's not my money at all. However, to the extent of employer's contribution, I would put it on the same pedestal as the company's obligation to pay wages and salaries. If wages and salaries has to pass through a waterfall structure, I find no reason why the employer's contribution should not pass through the same waterfall structure. People bring social security angle, etc., etc. I think we have my colleague Shikha also. She's my co-author in several insolvency books as well. And she also holds the view that gratuity is a social security contribution. It should stay out of Section 53, but I differ from her. To my mind, any obligation of the company, it might be owed to whosoever, but any obligation on the part of the company's obligation necessarily has to pass through the order of priorities in Section 53. So the Jetaways order, which is forcing a resolution applicant to pay beyond Section 53, and therefore to that extent it tinkers with the priority order of Section 53, to my mind, with great respect, is not correctly decided. We will, however, have to wait for Supreme Court ruling. Incidentally, there's another Supreme Court ruling. In fact, there are two other Supreme Court rulings which have actually made a dent in the insolvency framework. One of that is Vidarbha Industries. I'm sure all of you are familiar with the ruling, which said that despite there being an evidence of default, the NCLT may actually probe into the reason for default, and the default may be there, but it may not be qualitatively a default, and therefore the NCLT might decide that despite default existing, the case may not be admitted for insolvency. The Vidarbha ruling is, I think, day before yesterday, the Supreme Court has decided to review that ruling. So it's going for a review. Another ruling of Supreme Court, which is also in the case of Rainbow Papers, talks about the priorities of dues to the government. And it says to the extent the government has a right over the assets, because many tax statutes, in fact, most of the tax statutes will say that to the extent there is unpaid taxes to the government acquires the position of a secured creditor. That is, the government also to that extent becomes a secured creditor. And therefore, in the matter of Rainbow Papers, Supreme Court ruling, the other Rainbow Papers was NCLT ruling, but this one is Supreme Court ruling. This ruling also says that the government dues, it talks about Gujarat value-added tax law, but says the government dues also acquire the same stature as that of a secured creditor. Now, this also, and my colleague Shikha has written on this ruling as well. There are a lot of other write-ups on this ruling. But my colleague says that maybe the attention of the court was not drawn to the provisions of sections 26B to 26E, 26B, C, D, E. Of which law am I talking about? I'm talking about 26B to E of the... Shachi is going to say something.
The SURFACE Act.
Absolutely right, you're Shachi. SURFACE Act. So those sections are very important, because those sections actually say that the government may be in the position of secured creditor. The government may claim as a secured creditor, but in that case, the government must do an attachment. Merely saying that I have tax dues does not make me or does not put me on the same pedestal as a secured creditor. I have to do an attachment. That would mean I have to attach the claim to a particular asset and then register that claim with CERSAI. In absence of registration with CERSAI, a government attachment also will not stand as a security interest. Maybe the attention of the court was not drawn to these sections. These sections were enforced recently, so those sections perhaps were not brought to the notice of the court. So maybe I think that also might be one ruling which might be reviewed by Supreme Court. Shachi.
So thank you so much for so heartfully talking about the heart of IBC and acknowledge an insight. It was an extremely insightful answer. Sir, now I have a follow-up to this. Sir, recently, now the Jet Airways has been asked to pay the entire dues in full. So, in such a situation, do you think that the resolution applicants can now withdraw the resolution plan? Do you think this would be just, or would this be an unfair application of law? We would really like to understand your views, sir.
Mm, well, I think normally when anybody puts a resolution plan before the court, it typically also contains a clause saying that I submit myself to such changes as the adjudicating authority might like to impose. So one would have normally subjected oneself to changes as required by the adjudicating process. It's not unusual that the adjudicating authority requires the applicant to pay more than what he actually had promised. There are a lot of cases where the adjudicating authority has ordered the resolution applicant to pay in addition to what he originally proposed. Now, if the gap between what he has proposed and what is ultimately payable by him is so substantial that the resolution applicant says that, I mean, a conditional acceptance is no acceptance, and therefore, if the plan that I prepared has not been accepted, I've been ordered to pay more than what I had proposed. Therefore, my plan has not been sanctioned. Therefore, my plan doesn't stand, and therefore, I sort of bow out, beg out. If the gap is so very drastic, maybe the resolution applicant may take that stand. I think in Jetaways probably the RA has not taken that stand to my best of my understanding. I think there's probably some discussion about appealing this matter also to Supreme Court. I'm not sure whether it would have already been appealed, but there was some murmurs about appealing, but I'm not sure what's the latest on this. But technically, yes, if resolution applicant says that what he proposed and what's ultimately ordered is not the same, he can actually move out.
We understand, sir. Thank you so much for that insightful answer. So now, may I kindly proceed to the next question on the most heated commercial wisdom aspect of Committee of Creditors, sir, if I may have your permission.
Yes, please go ahead.
Okay, sir. The commercial wisdom of Committee of Creditors has held to be supreme, and it has always held to be out of the purview of judicial scrutiny. However, sir, there have been many instances where commercial wisdom results in either delays of the resolution plan or issuance of extremely large haircuts. And if I may read the numbers to you, Deccan Chronicle 95%, Usha Devi 94%, Videocon case 95.85%, and Xeon Steel 99%. And these are the number of haircuts, the percentage of haircuts. And it has also led to the apparent misuse of Section 29A that you were earlier referring to, sir. So, to deal with this, IBBI has recently released a discussion paper which buttresses on the need to regulate the operation and conduct of the Committee of Creditors. So, this is in order to circumscribe the unfettered and unregulated powers of the COC. What are your views regarding the same, sir? We'd really like to know your views. Thank you.
Mm-hmm. Okay, so let's maybe phrase it this way. First, the extent of haircuts. Shachi gave some numbers about the extent of haircuts going up to 99%. That's the extent of haircuts and what could be the reasons behind such very, very deep haircuts. Part one. Part two, we talk about the collective process of COCs. And part C, she talked about unfettered or maybe irresponsible behavior of the COCs. Now, let's maybe start first by explaining why the haircuts have been like the way they've been. So, one thing which we need to understand that when IBC was initiated in 2016 and thereafter the barrage of cases which were filed in the various benches, remember that these matters were actually insolvent for years and years. Most of these companies were running with absolutely mammoth losses for years. Their equities were completely wiped out. They had sort of gone into multiple rounds of corporate restructuring, evergreening, so to say. So they were actually accumulated piles of debt of years and years. If the initiation of insolvency is quick and I would say timely and quick, which is what it's supposed to be. If I find a business model is failing and there's no possibility of running it without an insolvency process. So if you are, let's say you have some health issues and you take years and years to visit the hospital, you made yourself a fit case for running up to the morgue. The hospital cannot cure chronic, many cases they cannot cure chronic cases. So the matters that went to IBC were essentially chronic cases of years, and they were actually dead long before they actually filed the insolvency application. So that is probably explaining the deep haircuts. Now, there might still be cases which are, let's say, failed business model. Think of a, let's say, technology company. Even though you file insolvency application soon enough, but the business model collapses. There might be a case of a complete value loss. This is something which is completely understandable. So the extent of haircuts may either be product of the actual depth of the depletion or erosion in asset values, or maybe a case of failed business model, a failed technology, or failed what you call connections which are required to make a business still work. That's part one. So merely by looking at the extent of haircuts, one cannot say that the COCs have acted unwisely. Part one. Part two. The key principle of insolvency is that as long as the business continues to perform and has the trust of its creditors, the creditors do not interfere in the management of the company. Creditors are creditors, they are lenders. They don't interfere in the management. They continue to watch from a distance. They are there. They might ask performance reports. They might ask what you call stock statements. They might ask periodical financial statements. But they are not there to interfere in the running of the company. As long as the directors continue to pay, continue to meet their contractual obligations. When contractual obligations default, the creditors take over, which actually means they file for insolvency. They might either go for a resolution other than insolvency, the so-called resolution framework of RBI. I'm sure all of you understand that IBC is not the only framework. IBC is more of a formal framework. There are a lot of informal frameworks as well, where the creditors actually huddle together and they do a resolution other than through IBC process. So in any manner where the creditors take a collective call that now it's time to interfere and step into management, the management rights are ousted and the rights then vest in the creditors. Now, the only way the creditors can work is through a collective process. If committee of creditors, and which is basically founded on the principle of democracy, if COCs have been a failure, I would say in so many respects, democracy could also be a failure. So COC is a shorter form of the democratic process. Democracy has its own merits, it has its own demerits, but I think the merits overpower the demerits. And therefore, we still believe in democratic process. So the democratic process of COC is still, I would say, valid. But that brings to the third part of Shachi's question, which is about behavior in COC. That's exactly where a whole lot of work is still required. IBBI has come up with a sort of a discussion paper on forming a code of conduct for COCs. To a very large extent, the code of conduct is like motherhood statement. Like a mother, ask the child to be a good boy, so the IBB is asking COC members to be a good boy. Now, that is still a pious statement of good behavior. I don't know whether it would actually have a tangible work. But other than this, there was another IBB communication which said that those members who attend COC meetings are attended by who? Who are the people attending COC meeting? Mostly bankers. 80-90% of the COC members are bankers. Now, I'm sure you understand that bankers in this country, they have a tremendous problem because they can't decide. If bankers were decisive, the company wouldn't have been in insolvency. And if the bankers become decisive during insolvency, the company wouldn't go into liquidation. Decisiveness is something which is missing. And that is unfortunately because the way the bankers work, the person who comes to COC meeting never decides in the COC meeting. And I have also been practically through this. And we've seen invariably the person who comes to COC meeting says, no, sir, I'll have to take it to my office, my HO, my seniors will decide. Because he's got a complete hierarchy above him. He can't decide. Neither can the hierarchy above him decide. So in many cases, indecision of the person coming to COC is backed by indecision of his senior. Indecision breeds indecision. So indecision is sort of perennial when it comes to banking sector, which is also because of the years of the so-called three C's which continue to frighten the bankers. The three C's that continue to frighten the bankers. I don't know whether you all would know the three C's. That says CBI, CAG, and Chief Vigilance Officer. CVO, CBI, and the CAG. They continue to scare the bankers. So years after the person is retired, there might probably be a CBI investigation or a CVO investigation. The bankers are scared of taking action. So that's something which is I don't know how can one actually take care of that. I think RBI is also sort of try to instill a confidence among bankers that if you take commercial decisions, you will not be persecuted for the decisions you take. After all, anyone who decides, the person who takes a decision has still got to be protected. Because if I'm persecuted for what I decide, then no one will ever decide. I mean, indecision will continue to prevail. So the larger evil, Shachi, is that the members who come to COCs are indecisive because they are not having clear authority from their seniors. If that can be resolved, I don't know what can actually be done to resolve it, but if that can be resolved, then the decisions can, then I think even the IBC may not be needed, because even the resolution framework of the bankers itself can take care of it. Shachi.
So, thank you very much for giving us a practical insight and a practical hint into this. Now we certainly understand where the delay is coming from. Sir, if I may, with your kind permission, may I kindly proceed to another question? Okay, thank you, sir. So, for long, ARCs, asset reconstruction companies, have asked RBI to give them a status of resolution applicants under the CIRP. However, for a very long time, the RBI again was indecisive about this. However, recently, the RBI has taken a sharp U turn and has decided to classify these asset reconstruction companies as resolution applicant under the CIRP. So, we would like to gauge your views on the same, sir. Please. Over to you, sir.
So while the RBI has now permitted ARCs to be resolution app, the master directions of the RBI to ARCs recently contain this permission, but it comes with two riders, two very significant riders, and therefore I am not sure if it's actually going to change the scene drastically. First, the ARC in question has to have net owned funds of rupees 1,000 crores. Of the 29-30 ARCs that we have in the country, I'm not sure how many of them have rupees 1,000 crores in terms of net owned funds. ARCs are not that heavily capitalized bodies. ARCs don't need that kind of a capital. Because ARCs are actually into issuance of security receipts. It's not their money that they put into buying of bad loans. They actually issue security receipts to investors. They are sort of, I mean, they are agents to resolve. They are not buying assets on their own balance sheet. So they don't need this kind of net owned funds. To my mind, I think there'll be barely 4 or 5 of ARCs which might have this kind of funding strength. So I'm not sure whether this itself is by itself a great bottleneck. Part one. Part two, even after the ARC does an acquisition under IBC, it can keep the business only for a maximum of 5 years. Now, for many businesses, even the revival process can take longer. To expect that a business will do a turnaround in 5 years and therefore churn money for the ARC, that also might be a little impractical. So though the RBI has taken this decision, but I think the conditionalities are still not really very helpful. Shachi.
Thank you very much, sir. And now that we're on the point of central bank and the prudential framework, so recently an appeal was, made by the IBBI chairperson for banks to, initiate insolvency at the earliest. On the other hand, the banks argued for having flexibility in this approach. While you have discussed about the COC and the delays that undertake in the meeting. We would like to understand your views on the same, sir. What could be the possible repercussions of such?
So, in their sheer banker's wisdom, banks would use IBC as the last remedy. For banks, IBC is not the first remedy at all. There is a resolution framework under RBI's guidance itself. Bankers would prefer to use the resolution framework because that's something which is more informal. That is something on which bankers have greater degree of control. So the resolution framework under RBI is the first choice for any banker. IBC is definitely not the first choice because IBC amounts to passing the control to an insolvency professional. Bankers would still like to have a banker governed or banker directed dictated process rather than an insolvency professional dictated process. So to my mind, the despite the appeals of IBBI chairman, I don't think bankers would be choosing IBC as the first remedy. And to my mind, rightly so, because IBC is, as I said, it's a collective process. That's the last remedy. It's not a recovery process. It's a resolution process. Bankers are more particular about recovery. Bankers don't care for resolution. Banker says my money should be recovered. I am answerable to my board, therefore I need to recover. So bankers should first be concerned about recovery. To the extent there is a loan which is backed by SURFACE, an asset which can be seized in SURFACE, I would like to use SURFACE. To the extent the process requires collective effort of all the bankers, I would go for resolution framework. But if none of these work, that's when one thinks of IBC.
Recovery over resolution, rightly pointed out, sir. Now we understand. So, with your permission, can I please take one last question from you, if that's okay?
Yes, please.
Okay, so thank you so much. So now that we're on the point of regulators, SEBI has recently provided for having a 25% market float upfront immediately after the insolvency. So here, SEBI has enabled public investors to subscribe up to 25% with 5% as a minimum cap. So, what do you think about the same? Do you think this would add hindrances in the entire structure, or do you think this is important in the interest of equitable equity investors? Sir?
So there was an discussion around that by one of the IPAs, ICSI, IPA, and I led the discussion on that. And the views of the gathering were divided. There were people who felt that this is something which is needed. There were people who felt that this would be an additional burden on resolution applicants. I also had a chance to interact with some people from IBBI also. And to best of my understanding, even IBBI is not very happy with this idea. However, from SEBI's point of view, SEBI is essentially the securities regulator, and therefore SEBI's views are inspired by minority interests. And SEBI still regards minority shareholders as those who are, most crucial for corporate democracy. Promoters are promoters. We all understand that companies may go into insolvency, promoters don't go into insolvency. Promoters would have taken care of their own interests even before the entity goes into insolvency. They are well protected, they are well taken care of. But as regards the minority, they suddenly find the company's stock value has become zero. Somebody else has taken over the company and my shares have been reduced to nothingness. So it's definitely a debacle for the minority shareholders, and therefore what SEBI was proposing. And to my mind, the proposal is, I would personally say that we have supported the proposal. We said this is perfectly justifiable. What SEBI proposes is as follows, that if resolution applicant of a listed company decides to bid for the resolution plan, he would ask the minority shareholders also to put 25% of the money. For example, if I am making a bid for, let's say, rupees 100 crores, I will invite the minority shareholders to contribute 25% to that 100 crores. If 5% or more of the rupees 100 crores sorry, comes from the investors, from the minority investors, 5% or more, In that case, I would take their contribution. I would allot shares to the extent they've wanted the shares to be allotted. Less than 5% comes, then the plan fails, and then the company will then go for delisting. But in order to ensure the minorities' participation, if the acquirer finds it's a good value to buy the business for rupees 100 crores, SEBI says there is no reason why that prosperity or the potential recovery of more money by bidding for rupees 100 crores, there's no reason why that potential should not be shared with the minority interests as well, minority shareholders as well. After all, they have been minority owners of the company since inception. The company went into insolvency. This is something that they couldn't have helped because they were not running the company. They have simply minority holders. Promoter himself is debarred from, investing in the so-called minority stake. The minority holders should be given the option of participating in the resolution process by being proportional resolution applicant by being allotted shares in the resolution applicant company to a limit of 25%. Now, this is what SEBI has proposed. A lot of people have opposed the idea, so we still need to see what will be SEBI's final take on it. But the jury is divided on whether this is right or not right. My personal view, I would support SEBI's proposal.
Thank you very much for your opinion on the same, sir. Sir, as a concluding remark, what do you think about the future of IBC? Where are we headed? Where are we now? We'd like to understand from you, sir.
So this is an interesting question, and I would like to answer that from two perspectives. Number one, from the perspective of the legal fraternity. You all are, either you are already a part of legal fraternity or you're probably headed to be lawyers as a part of your careers. Now, for legal professionals, IBC has been, I think, for the last 4 or 5 years, it's been a gold mine, so to say, because a large number of young professionals have come up. My colleague Chevy, who is also an advocate, and she would also confirm it, that in all the benches across the country, we find 25 somethings, young boys and girls who are newly qualified lawyers. All of them throng the courtrooms all over the country. So a very large number of legal professionals have come up, and thanks to IBC, because they got a new area of practice, the existing lawyers who were very comfortable with Companies Act, they were not as comfortable with IBC. So it was an opportunity for young legal professionals. So to that extent, I would say IBC is a great opportunity for all legal professionals in the country. IBC will continue to occupy a central place in the country's scheme of things because IBC is a very important law. As much as doing business is important, failures in business will also continue, and therefore businesses will go into insolvency, and therefore the ever increasing complexities of insolvency will keep needing legal professionals. No matter whether we have artificial intelligence or machine learning, as we were proposing earlier, the scope for someone who can digest legal principles, particularly from diverse perspectives, and weave it into a good case for NCLTs, will always be there. There will always be tremendous potential for young lawyers. That's part one. That's the future of IBC as far as you all are concerned. The future of IBC as far as the country is concerned, while it does require some tweaking, the good part is that wherever IBC requires tweaking, the regulators are always ready to do it. I would say the IBC was a great, given the fact that 60 years this law was pending and there were committees and committees trying to recommend it, but in a very quick frame of time, the BLRC acted, and then the draft bill and the final enactment were all done in great, I would say, great minimal time. So the fact that the government is responsive and the government is trying to bring amendments in the law as and when needed is quite evident from the fact that wherever there is something lacking, something missing, some need of the hour being shown, the government is always responding. For example, pre-pack was something which was being needed. The government introduced a pre-pack insolvency regime. The pre-pack itself has been highly unsuccessful so far because there are only 2 cases of pre-pack so far. And the pre-PAC regime also, I'm sure, will be reviewed soon enough. Cross-border insolvency in need of the hour, the government is probably responding to that as well. So what I'm trying to say is that there is a responsive regulator, there's a responsive, sensitized bureaucracy also, which is trying to propose amendments as and when needed. So we'll continue to reform the law, we'll continue to tweak the law to make it more practical, to make it more relevant, to make it work if at all we come to places where the law is not working. So as we continue to reform the law will continue to have a central place in the country. And I would completely be optimistic on the impact of this law in the country's economy. Chachi.
So, thank you so much for enlightening us about what has worked, what has not worked, and what we can work upon, and also giving a student touch to it. Thank you very much, sir. So, we received many questions since a seasoned professional such as you has come here. However, we picked these questions to ask you. And my personal favorite question was pertaining to the AI, and the way you beautifully answered that. Thank you very much, sir, for enlightening us about the
So I
same.
know who the querist
Sir, I
was.
would, sir, sorry.
So I know who the querist was.
Yes, sir. Yes. Thank you very much, sir. Sir, we'd like to let you know that some of these questions were drafted by our Center for Corporate Law members, Arshit Kapoor, who is a fifth year student at our university and who's also a mentor at Center for Corporate Law, and Devansh Sehgal, who's in fourth year currently, and he's the coordinator of our center. So, thank you very much. This was a very enlightening session. You're such an amazing teacher. I absolutely loved, and I've made a couple of notes as well. Thank you very much, sir. Shivani, over to you now. Thank you, sir. Thank you.
Sir, in the end, we are immensely grateful for your time. I am sure that the participants learned a lot about the issues in the area of insolvency and bankruptcy, but also your perspective on the same. I am sure that it has given us a lot to think about. We have tried to keep the session engaging and simple to understand for our audience since we are all students majorly, whilst also deliberating upon nuanced line of thought presented by you, sir. And in the end, if you have any sort of advice for us students in order to be better learners for corporate law or maybe even insolvency or become better lawyers in the future, please do leave us with any knowledge, any insights, sir.
Uh, so I think what I notice, I also taught at a particular law school for some years as a guest faculty. And what I notice is that to an extent, the fundamentals of the law, fundamentals of contract law, fundamentals of security law, fundamentals of trust law, these are extremely basic laws, and they form the foundation of the entire legal thinking, jurisprudence as we call it. So that jurisprudence basically comes from contract law principles. It comes from trust law principle to a certain extent. It comes from winding up principles of hundreds of years. So that jurisprudence, insolvency principles pronounced by courts over hundreds of years, winding up principles by courts, contract law principles, likewise trust law principles. These are founding stones of the legal thinking. I might study SURFACI Act, I might study Insolvency Law, I might study Information Technology Act, but I cannot be missing on the building blocks which is still lying in these so-called important pieces of common law. So my advice to all students would be never miss the common law principles. That's the founding stone. That's the foundation stone of all legal thinking. So please do respect the common law principles. That's exactly what forms the background. And I think with this, I would be wishing all of you very best in your future careers. Shivani and
Thank you so
Chachi, it
much.
was a wonderful experience.
Thank
I
you.
always love to interact with student fraternity. Arshit, thanks to you too. It's been a great
Thank you
pleasure,
so
and I
much.
hope you would invite me next time as well.
Thank you so much, sir, and thank you for complimenting the question. The answers were really insightful and really helpful.
True, sir. Thank you very much.